response time. As always, kindly wait until I recognize you by name before speaking. I will remind everyone, please do not speak over each other, as it'll be hard for our translators to translate and it makes their job very difficult. All comments and questions should be addressed through the chair. And members, please remember to raise your hand if you wish to speak. The clerk and I will manage the speaking order as best as we can. Thank you so much for your cooperation. Pursuant to Standing Order 1082 and the motions adopted by the committee on September 16, 2025, as well as on February 23, 2026, the committee is resuming its study on Canada's immigration system. And just as a reminder to everyone, this is part of the motion that we are looking at today is part of the overall motion around Canada's immigration system, and the motion that we have before us is that having regard for the February 23rd, 2026 National Post article titled Overwhelmed by Asylum Claims, Ottawa coped by ignoring security protocol, and further to its study on Canada's immigration system, the committee invite the Immigration and Refugee Board of Canada to appear before the committee for 2 hours at the earliest opportunity and no later than Wednesday, March 11th. And so I want to say that we're very blessed that we have not only the Immigration and Refugee Board here with us today, but also the Department of Citizenship and Immigration and Canada's Border Services Agency. So now I want to formally welcome our witnesses for today. From Canada's Border Services Agency, we have Brett Bush, Director General, Immigration and Asylum Policy. From the Department of Citizenship and Immigration, we have Jason Hullman, Director General, Asylum Policy, and Tal El-Harar, Acting Director General, Integrity Policy and Programs. And from the Immigration and Refugee Board, we have Manon Brassard, who's a chairperson, Rula Eat-Reedis, Deputy Chairperson, Refugee Protection Division, and Gary Dukeshire, Senior Counsel, Refugee Protection Division. And we only have a 5-minute introductory comments from Madame Brassard. If I can ask you to begin right now. Thank you, Madame Brassard.
Merci, Madame la Présidente.
Thank you, Madam Chair.
Today on the IRB's paper-based decision-making or file review process. But before I start, and in order to situate the process, let me say that every adult making a refugee claim is interviewed by an officer of IRCC or CBSA when they make their claim. This is the first step of the in-Canada asylum system towards refugee status or removal, where CBSA or IRCC decide if a claim is ineligible to be referred to the board due to security, violating human rights or international rights, serious criminality, or organized criminality. Ils questionnent le demandeur d'asile, recueillent les renseignements
They question the claimant to establish identity and determine eligibility. They gather biometric information, conduct immigration and police checks, and security checks through CBSA and CSIS. Based on the results, IRCC or CBSA decide if the claim is ineligible to be referred to the IRB, and if eligible, whether the minister should intervene on the case.
Once a claim is referred to the IRB, our role is to decide whether a claim is well-founded or not. We do not duplicate the work of IRCC or CBSA, but if at any stage of our process we detect something that should be raised to the attention of the minister, we formally notify them. Which takes me to the file review process. The file review process was not a response to the Yates report, although recommendation 26 did suggest that paper-based decision-making should be considered in as many cases as feasible. The board's authority to accept asylum claims without a hearing dates back to 1993 under subsection 69171 of the former Immigration Act. It is now found in paragraph 170F of IRPA. How and when we consider triaging a claim for the file process is the other point I'd like to clarify. We start by looking for a notice that the minister intends to intervene in the case. If there's one, the file is screened to a full hearing. Then we confirm that a front-end security screening, the FES, has been completed. If not, the file won't proceed in any stream until it is. When we look at the file for suitability to the file review process, We look at countries or claim types that have an acceptance rate of 80% or higher based on outcomes of regular hearings, where identity is established by reliable documents, where the evidence is non-ambiguous about the risk faced by claimants, and where complex and issues do not often arise at the hearing. And then there needs to be claimant-specific evidence, passport, birth certificate, membership cards, police reports, medical reports, in support of the claimant's specific allegations. If the requirements are met, we inform the minister of our intention to proceed, and the minister may choose to intervene, and if they do, the case will proceed to a hearing. Remember, triaging is an administrative transaction, not a decision. It allows us to use our resources in proportion to the nature and complexity of the case at hand. Lorsqu'un cas est confié à un commissaire,
When a member receives a file to consider via a file review, the member exercises their discretion, and if they feel it is warranted, they may direct the case to a full hearing. In 2025, 11,700 cases were finalized by paper-based review, which represents 12% of the 78,000 finalizations.
mais des dossiers est un moyen d'assurer un traitement.
The file review process is a means to ensure that claims, often from women where no issues of security have been detected and where the claim otherwise meets all the requirements of the Act, to the satisfaction of the RPD, can be dealt with more expeditiously. This allows the board to concentrate its efforts on the majority of cases that require a full hearing to decide. I will stop there, Madam Chair, and turn the meeting over to you.
Thank you so much, Madame Brassard. And now we will go to rounds of questions. The first set of questions will be each 6 minutes. And we begin with Mr. Redicott.
Thank you, Madam Chair. Thank you all the witnesses for being here today. Madame Brassard, I'm going to start with you. I want to talk, you said that the file review process was not related to the Auditor General's report in 2019, yet that seems to be when it was initiated. Can you clarify that for me?
As I said, the process existed since 1993. So it was called different ways, and it had different names, but it was not. So it existed for a long time.
Okay, so it did not start in 2019. It started in 1993. From what you said.
In one form or the other.
Okay, so now I just want to focus on the low risk part of this because in that Auditor General's report they mentioned that they suggested that you optimize procedures based on low risk countries, and yet the list of countries that was published at that time had a lot of countries on there that to me are not low risk, like Afghanistan, Iran, Russia, Syria, North Korea, these kinds of countries. So how do you define low risk?
Well, I wasn't there when that list that you're
Are you responsible for the department?
I'm responsible for the board, sir. So, and I'm really happy to do that. So, yes, let me go back to the list of countries and claim types that I'd
my
like
question,
to go back
to repeat the question, it's not necessarily the countries that are there, but the countries that I listed, to me, they don't sound like low-risk countries, and yet you're claiming that they are low-risk countries. Can you clarify that?
Well, you mentioned
North Korea.
North Korea does not have
Iraq, Syria.
Sorry, maybe I'll step in on North Korea has never been a less complex country. We actually take the position that North Koreans can be considered for citizenship in South Korea, so it has actually never been part of that list.
Can I just interrupt? Because I have the list from 2019. It says less complex claims in North Korea is on that list. Is this wrong? Is this document wrong?
We've never approved a less complex claim from North Korea. We, in fact, only have 2 claims in our entire inventory on North Korea.
So this document from IRB was incorrect then, is what you're saying? So
it was potentially an evaluation done at the time, and that evaluation may have changed over time.
So is there a current list now? Is there a list of these countries?
We don't look at it from this perspective. As I mentioned earlier, we look at country and country types and claim types, and we look at acceptance rate of 80% at full hearing as a starting point. And so there's never a real established list. It's a guide to look at where the kinds of countries that we would be considering.
So based on what? Is you're looking at less risk based on what?
If the acceptance rate is 80% at the full hearing.
Let me stop you right there. Acceptance rate of what? Of all people?
Of the claimants from that country.
So it is country-based then?
Well, we look at the country.
Like it's either country-based or it's not country-based.
Well, it's not only country-based.
So you said it's not country-based, and now you just said it's country-based. So which is it?
We look at the claims that we have. And then we look at the acceptance rates, and the easier way to start is country and then claim types. Because claim types vary from each country, within a country. And some claim types could get high acceptance rate, and others just about never accepted.
So what's a claim type?
A claim type, for instance, it can be whether religion. Is the group persecuted because they're Christian in the country, or because they're apostate? So that's a claim type.
So all. How do you know? So you're saying that all Christians from Afghanistan is a certain category, and if those people, as an example, would be automatically approved. Is that what you're saying?
We're saying let's take that example. So we know from the documentary evidence that Christians in certain countries are facing hardships and persecution. So that's a starting point to look at it. But I stated 4 or 5 criteria, and we need to go through all of them to decide whether that claim would effectually.
Let's go to a different place here.
Yeah.
Rules 26 and 27 of the Refugee Protection Division rules require that an asylum hearing must be halted if issues arise relating to fraud, false identities, war crimes, serious criminality, etc. Is that correct?
1 minute.
Yes, we have to, and we do. When we see something, we say something, and that's why we will stop the hearing and
right.
ask
So this
the
rule
members
exists
to,
so that the Minister of Public Safety or the Minister of Immigration can intervene to protect Canada's national security if something arises during the hearing, correct?
When it does during the hearing, we inform the minister.
And under the file review policy, refugee claims can be accepted without a hearing and without any questioning of the claim. Is that correct?
If the minister did not intervene.
Okay, and so if no hearing takes place and no questions are asked, the notification mechanism for those ministers in Rules 26 and 27 cannot be triggered. Is that right?
The minister has, and my colleagues can testify to that, they will look at the claims before it even gets to the IRB, before they refer it to the IRB. If they detect issues around security, if they detect issues around identity, they can tell us, and they do tell us that when they decide to intervene. And when that's the case, it doesn't go to the paper process.
Thank you very much, Ms. Brassard and Mr. Redekop. Next, we have 6 minutes for Ms. Sodi, please.
Okay, we can skip ahead of this because, like I said, we started a little bit late, so I can try to skip the Liberal round here. Excuse me, sorry. Let me see. About here. Oh, she's still going. Let me just skip this Liberal round, and then we should be live.
Their clients. So that's another claimant benefit.
An asylum seeker, first of all, the first step is the admissibility of, is that correct? And that is dealt with by whom? It's at the port of entry, at CBSA, and if it's inland, once they're arrived here, it would be IRCC. I'm sorry, the acronyms are in English. Okay, so it would be CBSA or IRCC. And when determining the admissibility of the request, what do you look at? Well, they look at the identity, security issues. They can talk to you themselves about each of the steps, but they mainly look at security and whether they are admissible. Have they already applied for refugee status here or elsewhere? There are a number of criteria, and also identity and security. So it's not a fine net. So when the applicant gets through this step, then they're referred to you. And then how does the IRB decide whether they will proceed with an in-person interview or not? We look, first of all, at whether the file is complete. The first thing that we look is whether the minister has manifested an interest in intervening, because when they give the steps, they can check whether or not they intend to intervene. Okay, then we expect to have a front-end security screening. It's a document by CBSA which conducts checks, and they can tell you more about this. They get checks from the RCMP and other law enforcement agencies. And they conduct checks, security checks of people who have submitted applications. So they verify who they are, their identity, whether they've committed crimes, serious criminality, and that is a check, an overall check, and all the questions that they're allowed to ask. And that's why I refer you to them for the first step of admissibility. And then the process continues. And then we do a front-end security screening as well, and we know that they have passed that. And what determines whether there will be an in-person interview or an in-person hearing, or whether there isn't one? The complexity of the file, if the minister has signified their intention to intervene, and that in what proportion of cases does that occur? I would say 5 to 7%. So let's say there's no intervention from the minister, then we look at what sort of claim it is. If there are complex legal issues or factual issues, that goes to a hearing. If there are issues requiring where the documents don't really support the claims or it's contradictory, we question them on their ability to about protection mechanisms outside of their country. We send that to hearing. If they don't really have many identity documents or to support the claimant's claims, or they don't have traditional documents, we need a complete document, and the board, well, because they've conducted a triage, the commissioner may feel that, well, there's still some information missing, and that could be sent to the normal stream for a hearing. And they do that between 35 and 60% of the time. And when the commissioner is satisfied, they can move to a hearing. I'd ask you to explain at what point. There was the article in the National Post that talked about a one-step system. At what point does that come into play? If the asylum seeker comes from a certain number of pre-selected countries, they'll be automatically set aside for a hearing? Well, it's a bit of a red herring in English, as we say in English. We need to start somewhere. You have 1 minute left. I'm sorry, wrapped up? No. You have a minute left. We look at the merit of the claim. There are countries for which documentary evidence is clearer. And then, and we start that way. But it's also what we call the claim types. Haiti, to take a country, women subject to persecution. Well, I just have 20 seconds left just to understand what you're saying is that in some cases when the applicants come from pre-selected countries, they are referred, and if they have a high rate of acceptance, they are referred to a documentary analysis without hearing. That is true? Yes, but you need to understand why. So how many people have been able to benefit from that stream without having a hearing? Well, from 2019 to today, about 23,000. So that's an additional 10,000. And could we get the breakdown? Thank you. Thank you, Mr. Deschênes. Thank you, Madame Brassard.
Okay, next we go to rounds of 5-minute questions. So we start off with Mr. Menegakis.
Thank you, Madam Chair, and thank you to all of our witnesses for appearing before us today. Madame Brassard, I'd like to start with you. What is the name of the alleged IRGC official whose identity the IRB hid as reported on February 6, 2026?
I'm sorry, say that again?
I would like to know the name of the IRGC official that appeared before you and was reported in the Global News Report on February the 6th, 2026.
That does not ring a...
It's a Global News Report. And basically, it says a suspected high-ranking Iranian official caught living in Canada appeared at his deportation hearing on Thursday of that week, and the IRB
Oh, what the hell?
deemed it necessary to not divulge his name. We'd like to know his name.
I don't know his name.
You don't know his name.
I don't-
Your department was there. They're the ones.
Yeah,
You-
but I don't know the name of every single person who makes a
So
claim.
you don't, this does not ring a bell with you?
Yeah, well, the case does. The name, I don't know.
You don't know that.
And the name is confidential.
Why is the IRB prioritizing the privacy, then, of an alleged member of a terrorist organization over the safety of Iranian Canadians?
You mentioned alleged.
Then why hide his name?
Well, if they, hypothetically,
Well, let me talk facts, not hypothetically. I represent a community of probably the region where the highest population of Iranian Canadians are living in Canada. That's the Richmond Hill area. And there are these folks out there that came into the country that should never been allowed here in the first place, that are basically terrorizing people in the community. They should not be here in the first place. And it appears the IRB has taken a position to not disclose their names. Does the IRB grant the same level of anonymity to other terrorist organizations, say like ISIS or Al-Qaeda? Or is it just specific for the Iranian community?
the legislation provides, generally speaking, that when someone makes a refugee claim, that claim becomes in camera, and we have to protect the identity of refugee claimant in all the hearings that appear before us. So generally speaking, that could be the reason.
Okay. But do you not see the need to protect the community? The community needs to know who these people are walking amongst them.
We apply the law, sir, the way it is written right now.
Of the hundreds of thousands of pending asylum claims, how many belong to individuals with alleged ties to the IRGC?
Well, I don't have a number to give you right now.
So do we know how many are in the queue for deportation?
That would be a question for CBSA.
Well, the CBSA has located 26 that merit deportation hearings. Maybe I'll ask that question to Mr. Bush. How many are in the queue for deportation with ties to the IRGC?
I don't have the specific data on me, but I can take that away and try and get that data for you.
Okay. Could one of you answer why there has only been one deportation in almost 4 years?
I can't, like I said, I don't have the data in front of me, so it's hard to answer your question without the specific data on those cases.
So back to you, Ms. Broussard. Is it acceptable to you to just have like one person deported in 4 years from the list of people that you deemed should be deported?
I have no comments to make on that. You'll understand that once we've made our decision, it is out of our hands what happens after.
Look, the CBSA found Afshin Pernoun. They alleged this 50-year-old was not allowed in Canada because he was deemed a political asset. Yet the IRB said he did not exert significant influence and allowed him to stay. What is the threshold? What's the IRB's threshold for significant influence if a 22-year official in the Iranian regime does not meet it?
30 seconds.
It depends on the degree of involvement that official has in the decision-making of their government. And that is something framed very much so by the federal court, and that's what we apply.
Should regime backers promoting and executing IRGC business be allowed to stay in Canada, in your opinion?
We apply the legislation as it is, sir.
Thank you, Mr. Menegakis. Thank you, Madame Brassard. Next, we have 5 minutes for Mr. Fragiscatos.
Thank you, Chair. Thank you to the witnesses for being here today. I want to go back to file review.
Okay, we're going to skip over this Liberal round because, like I said, we started about 20 minutes late because I forgot the clocks changed back. So let me skip past this Liberal round. Listen to the block round because he's actually been all right.
Them know as much, and just as much as we let them know.
And basically, what he was saying there was what the Conservative was saying there is that there's 26 known alleged IRGC individuals in Canada that are already, known are linked to be deported, and only one of them in the last 4 years has been deported.
Next, we have 2.5 minutes for Mr. Deschênes. Thank you very much, Madam Chair. Madame Brassard. What does an in-person hearing add to the process? It's useful when there are doubts about credibility, when there are legal issues that need to be addressed to a lawyer. So we test those issues. And earlier you said since 2019, 35,000 asylum seekers, yes, 18%. 18% in Quebec, 35,000 asylum seekers since 2019, and your numbers are up to date for December 2025. So 35,000 asylum seekers who did not go to hearing. Is that correct? And you said of that number, 18% were in Quebec. Okay. And if an asylum seeker comes from one of the pre-selected countries that's part of your project, is it still possible, if something arises, that asylum seeker be referred to a hearing? Absolutely. And earlier, you also said that 10 to 12% of the asylum seekers last year, that was part of the 35,000. 1 minute. And of all of the asylum claims, there are 10 to 12% that go to a hearing. Go without a hearing. Okay. 10 to 12% go without a hearing. There are a hearing for most, or we call them to come to a hearing, and we declare them abandoned because they don't attend, or in a very low percentage, people who just abandon, who withdraw their asylum claim. Okay. Thank you. Thank you, Mr. Deschênes. Thank you, Madame Brassard. Next, we have
Rempel Garner.
Thank you, Chair.
Get her, Garner.
To Ms. Brassard, the law says under IRPA, right, Section 130 or 166, I believe, is that proceedings before your division must be made in public. Is that correct?
Not for the refugee claimants.
But actually, Section 166 does say that, right? Any division?
I don't have the act with me. But
I do. It does. Okay. So the next thing is that the story my colleague mentioned said that before arriving in Canada, the Iranian citizen was a senior member of his government, according to the Border Services Agency, which asked your division or your board to order his expulsion. To Mr. Bush, would your agency have recommended deportation based on those grounds without significant evidence? Like, would you have told the IRB that he should be deported, this person should be deported because he was a senior member of the Iranian government if you didn't have evidence to that effect? Would you have made that up?
So thank you for your question. What I will tell you is the process of it all. So the officer...
I'm just, yes or no? Would you have evidence?
Yes.
Okay. So, Ms. Brassard, in what universe would you go against Section 166 of the law, of your law, and withhold this person's identity from the public? Why would you do that?
Madam Chairperson, if I can just specify, actually, Section 166 of the law specifies that all proceedings before the Refugee Protection Division and Refugee Appeal Division are held in the absence of the public, so confidential. And any claim before the Immigration Division...
This is a deportation hearing, though, right?
Please.
Point of order, Madam Chair.
Any
Point of order,
case
sorry, Mr. Zuberi.
I'm just hoping to hear the full answer from the
I'm hoping
witness.
to use my time. Thank you.
Thank you, Mr. Zuberi.
The time. Thank you.
Madam Chairperson, if I can just clarify for the Immigration Division, all proceedings before the Immigration Division are also held in the absence of the public if they involve a refugee claimant. So, or if the member orders a confidentiality order. So not all
Okay, so here we are. So this
issues
person,
before the Immigration Division.
this member of the Iranian regime wanted his hearing in public and you or in private, and you guys granted it. Why? What possible interest would that serve the public, whose gyms
Oh my God. It's crashing out
are
again.
being shot up by these guys right now? Why would that serve the public's interest? Like, I mean, you're saying you don't even know who this person is, and now you can't tell us why this would be in the public interest to withhold his identity from reporters?
The legislation says that we withhold identity when the claimant, if the person makes a claim to refugee status.
Yes, why would you protect the identity of a senior Iranian government official in Canada on a deportation order requested by the CBSA? That's crazy.
Okay, well, that's your view. The way we present...
No, I think that's the public's view.
Okay.
I think that's logic. Is it not your view?
My view is we have to apply the legislation as it is.
No, you made a decision to hold this in private. Why?
Because it was the member's decision to look at the evidence.
You said you didn't even know who this guy was.
Point of order.
I don't need to know who the
Point of order,
claimant
Mr.
is.
Fredescatos.
Again, we're trying to hear the answer, and we cannot.
Okay, let's give time for Ms. Brassard to give her response, please.
Thank you. When the department comes and asks for somebody to
Okay, I've heard enough.
Okay.
The second thing...
No,
it's
Ms.
my time.
Rempel-Garner.
It's my time. The next thing I
okay.
would like to ask is this. Ms. Brassard, would a former director under Iran's Ministry of Roads and Urban Development, who was a 22-year civil servant with ties to the Iranian regime and described as a political asset of the regime, would they be considered a senior official under the law and be ordered to be deported?
Depends on the nature of the evidence adduced.
Do you think
during
that
the
they
hearing.
should be considered a senior official?
It depends on the nature of the evidence.
Mr.
1 minute
Bush.
left.
Mr. Bush, would it be easier for your department to deport Iranian officials, people with ties to the regime, if the law was changed to clarify that non-citizens with ties to the regime would be deemed inadmissible if involved in regime-linked businesses, spreading propaganda, or human rights abuses? I'm thinking of cases like there was a guy that was the head of the Iranian state-funded newspaper, was the deputy political leader of the Friday Imams Policy-Making Council, the supreme leader's head of office in the UAE, and has not been deported. Would maybe changing the law make your job a little easier there, Bud?
I'll leave the questions of changing the law to Parliament. But in terms...
I'm trying to make a suggestion to change the law because it seems crazy to me that I'm arguing with the head of the IRB that we should be protecting the identity of a senior Iranian official when members of the Iranian diaspora communities are having their businesses shot up in Canada.
Thank you, Ms. Rempel-Garner. Thank you, Mr. Bush. Next, we go to 5 minutes for Mr. Zuberi.
Thank you, Madame Chair. Merci à les témoins d'être ici aujourd'hui.
Thank you to the witnesses for joining us this morning.
Down a moment, because I know there's been a bit of a charged environment in this committee. I would like to just talk about the rule of law and the IRB and its role in implementing...
Okay, so this is probably the
rule
last
of
time
law.
I can skip the liberal round because at this point it's going to be live. So let me go to just live, and then we'll be caught up.
The numbers, most of the people that we're detaining are generally speaking for removal, so I would have to believe there are some of those people that are released after we have detained them the first time.
Okay, so just to be clear, you are confirming that people that have been detained for deportation have, prior to deportation, been released back into the community?
What I said, sir, was, oh, sorry, Madam Chair. What I believe I said was that I believe that is probably true, but I don't have the data in front of me to confirm that for you.
Well, that is something that I would also, again, ask that for an undertaking from you to provide the committee with some data on the number of people that have been in detention awaiting deportation that have been released back into the community prior to deportation. And then I'd also like to follow up and say, do you have any data on those people that were released that actually were then deported, or are they still effectively at large hiding in Canada?
With me today, no. I obviously I don't have the data on that series of questions, so yes, we can undertake to get that for you.
Okay, I think it's really important because as the pressures in the citizenship file across the board in Canada, we are seeing a need for increased capacity, not decreased capacity. But do you have any data on the capacity holding changes or detention capacity at border crossings in Canada? Has that changed in the last year? That's fully within your jurisdiction. So any detention capacity reduced at border crossings in Canada?
So your question, if I can clarify the question is, have we changed our ability at any of our border crossings to detain people while they're crossing the border?
Has there been any capacity changes in detention capacity, say, for example, at the Peace Bridge? Has that capacity decreased in the last year?
I will simply say not that I'm aware of, but I would have to take that back and confirm.
Okay. How much time do I have, Madam Chair? 1 minute. 1 minute. At the CBSA, and I just want to go in a different direction here, the minister touted last week that the first cohort of graduates of the new 1,000 CBSA officers had taken place. How many of that 1,000, or was it 1,000 first of all? Do you know if it was actually 1,000 people that were graduated in that first cohort?
I don't know what the cohort that graduated, the number that was in it last week,
Okay.
so I apologize.
Would you know what the actual capacity is for training new CBSA officers is at any given time? And I would suggest it's much less than 1,000.
I think that is true, but I'd have to take that away and get you.
So
to answer your question, I'd have to get that for you.
I would appreciate that. So within the confines of this recent graduation, would it be unfair to suggest that that cohort is simply filling gaps in the system that take place on a normal basis year over year?
Since I don't know the number, I can't answer that question because
Okay, do you know what your turnover is every year in pure numbers at the CBSA?
Do I know? No, I don't.
You don't.
Thank you, Mr. Davies, and thank you, Mr. Bush. Next, we go for 5 minutes to Ms. Sodi.
Okay. Thank you, Madam Chair. I just want to go back to our officials from the IRB, and obviously whoever wishes to answer may do so. Are you able to provide a specific example from a specific case that has gone through the file review system that you've implemented?
As you understand, I can give you claim types and examples, not a specific. This is, of course, confidential. When we look at China, for instance, like if there was a case there, we would be looking for what kind of case that would give us this. Christians, Tibetans, Uyghur, it could be people we would look at types of claims to see if the evidence is there. So if there is a minister's decision to intervene, if there's a FES, and is the FES detecting anything suspicious, which would indicate not to go to that process. And then we would look for the evidence, the global evidence on the situation of those groups. And then we would also be looking for claimant-specific information that would show and assure us that they are Tibetans or that they are Christians or Uyghurs, and that they have suffered and have reasons to fear persecution because there is police reports, doctors' reports from there and from here. So to bolster the case and make sure that it clears all the questions one might have. And then if we find something wrong, we send it to the full hearing.
Okay, perfect. Thank you so much. I just want to shift to the members from IRCC today as well. Are you able to walk us through the basic steps of an asylum claim from arrival in Canada to a final decision?
Sure. Thank you, Chair, for the question. So I think some of that was already alluded to before, but I'll try to kind of go in a sequential order. So somebody who is making an asylum claim can do that either at the border when they arrive or after they've been in Canada for some time. If they make that claim at the border, they would make it to a CBSA officer. If they make it in Canada, because they may have been here already, they would make their application online and then be directed to an IRCC office to finish the intake process. In the initial kind of intake process, we use that to confirm somebody's identity, to collect the biometrics from the individual, seize travel documents, and determine eligibility. I think, as was mentioned before, there are multiple criteria for ineligibility, including having filed a refugee claim before or for security concerns. Once those steps are completed, the person is given a conditional removal order. So that was mentioned already too, in that the person doesn't have really an authorization to be here, but because they have filed a claim, the removal order is stayed while their claim is going through the process. They would then receive as well a confirmation document that indicates they're a refugee claimant, so an identity document. The claims are, depending on the process, referred to the Immigration and Refugee Board, but security screening is conducted on 100% of the claimants. While the claim is pending, we also review those claims and triage them to find indicators either of additional security concerns or credibility and integrity issues. So that's where you're hearing the reference to interventions. And the interventions is basically the minister, so staff, providing the evidence that we may have access to of those from an IRCC perspective, integrity or credibility questions. That could be things like multiple undisclosed identity. It could be something like they have permanent residence or protection in another country. Something that we have seen in their claim information contradicts other information that we might have in their immigration documentation. So where we have those concerns, we will prepare either a written intervention or for the ability to go before an oral hearing and provide that information so that the decision maker at the IRB can take that into account as the claim is being decided. Once the claim goes through the IRB decision-making process.
Thank you, Mr. Holman. Sorry, that is time, and thank you, Ms. Sodi. Prochaine, on a 2 minutes et demie pour Monsieur Deschamps.
Next 2.5 minutes for Mr. Deschamps. Thank you, Madam Chair. Ms. Brassard, what is the current processing time for asylum claims in Canada? For someone receiving a decision now, it's about 24 months, 17, and everything this from the step of admissibility. What are the processing times specific to Quebec? I think it's about the same.
C'est marginal.
It's roughly the same. So 25 months, 24 months, it's roughly the same. We manage our workload nationally. So if a case can be heard earlier with a commission or elsewhere, then we do so. I understand that every country's is different and every immigration system is different. But we see in some European countries they seem to process the claim and within 6 months. What would allow us to reach that level? First of all, you need to look at how they calculate that 6 month. Some countries stop the clock. And that, of course, reduces the processing time. The time doesn't count when they're waiting. So you need to take those numbers with a grain of salt. And it's also a question of workload, how many files they receive annually, and what are the resources and the number of commissioners who work on it. And the fundamental question is more, how could we shorten processing times here in Canada? Well, we continue to do a lot to address the creation of the file. It's not the hearing that is slowing things down. It's everything that comes beforehand. We have to do ministerial due diligence, and that takes a lot of time because we need to wait and we need to seek out information and remind people that information is missing. That's a lot of energy and time. And then we are ensuring that the files that we receive are in all sort of formats, fax, paper, email. We're trying to create a system that creates an e-file that's more robust and use a more systematic approach. We did a review of all of our processes. Thank you, Madame Bressard. Thank you, Mr. Deschênes. Next.
Mr. Ho, sorry about that. I didn't know what he was pointing to. So, Mr. Ho, please, you have 5 minutes.
Thank you, Madam Chair. My first set of questions would be for the officials at the CBSA. So, a Globe and Mail report on March 6th had reported that the CBSA was investigating 95 cases involving possible high-ranking Iranian regime officials. Could you confirm that figure?
I can confirm we're investigating cases. I don't know the number. So I apologize because I'm from our policy area, not from our operational area. So I was here to talk about this.
There are officials that are, you're aware that the CBSA is aware that there are senior ranking Iranian regime officials living in Canada. Some number of them.
We are aware.
Okay. And the CBSA reportedly concluded that 28 individuals were deemed inadmissible after the government announced back in November 2022 that senior Iranian officials should be barred from Canada. Is that correct?
Again, I can't confirm the number for you today, but there is a number of cases that we have. Yes.
We'll go off what your agency said to the Globe and Mail. So yet, despite identifying 28 individuals that are deemed inadmissible, only one person has been removed from Canada since 2022. Is that correct?
Again, I don't have the number in front of me, but...
So assuming those numbers are correct, because the numbers were provided by your agency, sure. CBSA, to the Globe and Mail, why is the enforcement rate so low?
So we have to keep in mind that the whole system is predicated on due process. So we start with an allegation where we write a report. It's reviewed by a senior officer to decide if there's enough evidence to refer it to the board for a determination of admissibility. It would then go to the board to be scheduled for a hearing. I can't speak to the processes at the board. My colleagues can.
That's fine.
If a decision is that the person is inadmissible, then of course, you have different review mechanisms that exist for people. And then once those are all taken care of, then we would remove them from Canada.
So what exactly is preventing the CBSA from removing these individuals that have already gone through the IRB due process that exists, so that have been already ordered deported?
So if they've been ordered deported, then you get into the mechanisms of having to be able to remove them. So I can tell you what one of the big problems today, on today's date, would be, is access to flights into Iran. So
given the escalating instability in the Middle East and the regime's global activities, is your agency concerned at all that these regime officials may attempt to seek safe haven in Canada?
I think we have to take a step back and just look at what mechanisms have been put in place. So Global Affairs has mechanisms for sanctioning Iranian officials. The government has also put into place, under our minister's authority, 2 measures. So there's the listing in the criminal code of the IRGC as a terrorist organization, and then there is the designation of regime, which your colleagues have asked questions about previously. So all those mechanisms exist. So
are you satisfied with those measures? I mean, that you've listed a lot of measures there. Are you satisfied with how, with the measures? Are you satisfied with how is it rigorous enough in your view?
If you're asking my personal opinion doesn't really matter for the purposes of this conversation, but there are a number of mechanisms that exist.
But you oversee a lot. You see a lot of this stuff,
including.
So you would have an opinion. I mean, we're asking you because you see a lot of this stuff on the ground. So we were asking you. Do you think that there could be things that could be updated in terms of measures?
Me personally, if you're asking me, do I believe the if I believe the admissibility regime is intact to find people inadmissible for coming to the country, yes, I do.
Wow. So you don't think there should be any laws that need to be updated?
I didn't say that. I said, you're asking me about the Iranian situation and senior officials.
If the laws were updated, would it make your job easier? Would removals be quicker in review? If we were able to change the law.
The hypothetical would depend on what changes you're looking to make.
But there could be some changes that could speed up removals. Right. So lastly, I'm just going to ask, Iran's Deputy Interior Minister, which was found in Canada, Syed Samani, has he been removed yet?
I honestly don't know.
He's been ordered deported a couple of years back, and he's a pretty high-profile figure. I mean, it's all over the news. Has he been deported?
I think I just answered that question, Madam Chair. I don't know.
Thank you, Mr. Bush. Thank you, Mr. Ho. That's your 5 minutes. Next, we have 5 minutes for Mr. Fragiscatos.
Thank you very much. Mr. Bush, I'll continue with you, sir. You just said, and I quote you directly, Canada's inadmissibility regime is intact. You have confidence in that. Can you expand on that?
So, asking me for my personal opinion is one thing versus where the government sits, but
it's not a question that is seeking your opinion.
So with regards to the admissibility regime, there are provisions for finding people who are involved in terrorism inadmissible. There are provisions for finding people involved in espionage inadmissible. There are provisions for people being involved in human rights abuses, criminality, organized crime, the full gambit of inadmissibilities. The provisions themselves exist to be able to, and the question I believe that your colleague had asked was with regards to, will it keep people in the senior officials of the Iranian regime from coming into Canada? And I believe between all of those things, including the designation of the Iranian regime, which includes 50%, the top 50% of those officials, it will keep the decision makers and the organizers of that regime from being able to come to Canada. But we also need to keep in mind there is going to be challenges as of this past week to be able to travel out of the region to be able to make that move in the first place.
Understood. Thank you very much. Madame Brassard, in the exchange that you had with my colleague, Mr. Zuberi, this was not said directly, but it did strike me as an important point, and that is that the individual before the IRB who's making a claim, the onus is on them. The onus is on them to show that they are a legitimate refugee, correct?
Absolutely. The onus of proof is on the claimant to establish their claim and all aspects of the definition of a convention, a refugee or a person in need of protection.
Okay. So if they don't present, these are basic facts, I understand, but with so much being said and so much being implied, I think it's important to clarify that where the onus lies.
Absolutely.
So thank you for that. Let's go back to file review, because there's been so much said and implied. The CD Howe report, you were asked about that, and you spoke to that. But I want to look at other countries here for a moment. Are there other countries that employ a similar process that you're aware of, or that colleagues of yours would be aware of?
Different countries use different process, like I said, tier 1, tier 2 decision making and stuff. But for one, Australia has a paper process.
Yes.
And it's for what I call manifestly founded claims. So where a hearing wouldn't add anything to what's already in the file. So it does exist elsewhere, and it is this proportionality, using proportionality of a level of effort to the need of the claim or the file, so that we put the appropriate level of resources and energy, is something generally done in administrative tribunals and elsewhere.
So Australia uses an approach like that, a Commonwealth partner. There are presumably other countries. We don't have to go into the specifics of that, but
presumably we look at one way or the other at simplifying the process, particularly for very obvious claims.
Yeah.
I believe UK may have something similar, but they're not necessarily exactly the way we do it, because every system is somewhat a little different.
And I think I have just a few seconds remaining.
45 seconds.
45 seconds. Thank you, Chair. For the purpose of the record, 90% of cases that come before the IRB are given a hearing. 10% go to file review.
Just about maybe 88, 12, but yes. And it's either a full or an abandonment hearing, or they withdraw.
And once again, any case, all cases, to be clear, that go before file review have already been looked at by the CBSA and IRCC.
Yes, and have been given a repeat chance to intervene when we think a file is suitable for the process. We formally advise in each and every single case, so that if they have since found something, they can intervene.
And there is that.
Thank you, Mr. Fragiscatos.
We'll
Thank you,
stop there.
Madame Brassard. Next, we have 5 minutes and we are now into our last round of questioning. So, Mr. Redekop, we have you up for 5 minutes.
Okay. So my first question is for Mr. Bush and CBSA. So we were talking about Syed Solomon Samani, and you indicated previously to my colleague that you don't know if he's been deported or not. I think it's a very relevant question that a lot of Canadians are wondering about, and this committee is wondering about. And I'm wondering if you can find an answer to that question and table it with this committee by the end of the week. It should be a fairly easy thing to find out. Is that something you can do?
Well, I can take that back to the agency and have my colleagues who are responsible for that provide a response.
Okay, by the end of the week, that would be great. Thank you. I want to go back to the Madame Brassard and the list of countries, because I'm a little bit confused, because I was looking at this list. You said there wasn't a list, and then you told my colleague, Mr. Duchesne, there's a list. Is there a list of countries that you use in the file review process?
We work with source country, 220 countries. Like, people come from all around the world. We have developed an expertise at the IRB over the years, and we know which kinds of claims from will likely have a serious.
I'm just going to interrupt you because I have very limited time. So just specifically on the list, so are you saying your list is 220 countries then? Is that what you're telling me?
What I'm saying is, I think what you're trying to look is there a list? And if you're not on the list, you're out. We're
Right.
looking for,
Like this one right here.
well,
Like
that's
this-
an old list that existed then.
Yes, correct. So
Okay.
is there an equivalent to this list today?
We look at the claims, and we know which countries with the 80% acceptance rate. So
Okay,
that's sort of
so
the
let's
starting
Let's
point.
pause right there. So there is a list then? Is that the answer to there's a?
Well, it's not necessarily a stable, like, we're live to the issue. If
Okay.
a country stops being 80%, it'll drop. So we don't keep a list that we keep updating. We know what we have by way of our caseload and how what's coming out in the decision-making of the full hearing.
Okay, so I'm still very confused, because you're saying that, you're kind of implying, that, like, if I was working in your board, there would be some list that would say, today we're concerned about, whatever country, pick a country, China. Tomorrow maybe something changes, we're not. So that's a list, is it not? Or there is no, like, how does a person know what countries would be subject to file review? Is there a procedure?
You want to explain the procedure?
I don't need to explain the procedure, I'm just wondering if there is a procedure.
Go.
Yes, there is a procedure. So files come in and we look at.
Okay, let's stop right there. So like on this sheet that I have, which I admit is from 2019, it says on here, instructions governing the streaming of less complex claims at the Refugee Protection Division, and then it talks about, that's where we get this list, and I assume there's more to this document. Is there a current document like this?
No, we don't publish anything like that anymore.
No, I'm not saying published, but does IRB have such a document for internal purposes?
If I'm able to tell you the claim types for certain countries, it's because we keep track of what we're doing. So, but in terms of a list, the way you see it there, we've moved on from this kind of approach.
Okay, so let me ask it differently then. Would Iran currently be considered something under file review right now?
It has been.
Okay, so so you have a claim type from Iran that would be dealt with there. And Mr. Holman, I'm going to ask you this question. Do you have concerns about document accuracy, fake documents, just in general?
I mean, I think a part of the integrity process across all three organizations looks at the types of information that people provide, including the documents they provide to support their claims.
Do you find fake documents? Is that something that occurs?
I would imagine across the system, yes,
Okay.
we are finding.
Okay, so Madam Broussard, you said that you would take a claim from, let's say, Iran as this example, and you would say that it fits into, I don't know, a woman at risk. You have documents from her. How do you know that those documents are correct? How do you know that it's not an IRGC official that is trying to get his family to Canada? How do you know that?
Well,
30 seconds.
That's why we wait for the front-end security screenings. Like if there's an issue there, we will know. We also have a research directorate that has samples and copies of what a legitimate document should be. So there are comparisons. And if we have any doubts, we just don't send anything.
So
to
you
the
have
paper
a
process.
you're confident you have a robust way of detecting fraudulent documents?
We have a pretty solid way of finding, and it's a system issue. It's not just the board. There's just as much, if not more, concern about it than we are. And sorry, I got the message.
Thank you, Mr. Redekop. Next, we go 5 minutes to Mr. Zuberi.
Thank you, Madam Chair. Et, Madame Broussard, j'aimerais donner vous le temps.
Madame Broussard, I'd like to give you the time to respond or elaborate on the points that were raised here.
And clarify points. I'd like to give you that time.
I would say is the system is a system as a whole. It starts with CBSA and IRCC, continues with us. We are all very concerned about security issues and integrity issues, and we take it seriously. That's why there are so many processes. And that's why we look at each cases so carefully.
Okay. I wanted to just, if you can elaborate a bit on the process. You did touch upon this already, but the process, and maybe it's also for Mr. Bush, the process before a file gets to the IRB in terms of some of the, you just mentioned the security screening aspects. If you want to elaborate further on that.
That's probably.
Yeah, that's
yes, please.
Thank you. So, as I mentioned, this starts at intake with the application, the information we collect, trying to identify admissibility concerns beyond just the person is not compliant with not having a visa to immigrate. We then move into the security processes that involve both CBSA and CSIS to identify is the person a security risk or not. And so that is using all of the assets that we have available to us to be able to collect, but obviously I'm not going to discuss them in detail in a public hearing. And then for the people, which happens to be less than 1%, where we find there are security and admissibilities or security concerns. So I say that very specifically because there's two pieces of legislation in play here, because there's the CSIS legislation where they're dealing with threat, and then there's the Immigration and Refugee Protection Act, which is dealing with admissibility. And then we get into the processes around the interventions and being able to intervene at the IRB with representatives from CBSA to articulate why the person should not get protection, because one of the foundations of the UN Convention is people involved in, I don't have the convention in front of me, so I'm not going to quote it correctly, but I think it's crimes against good order in the world, or it's some very... Yes, so war crimes, crimes against humanity, terrorism. This is how Canada defines it for the purposes of going back to one of the questions earlier around ineligibility, to keep them from being able to have a claim assessed at the board, and the exclusionary criteria. So we argue that before the board, and the board would make a decision.
So picking up on this issue of screening before getting to a certain point, in previous meetings there was a conversation around one touch. Can you speak a bit about that process that happens before a person actually touches that one touch? What's happening before that one touch is actually happening? We have about a minute 45.
So I tried to explain it earlier. The big people get interested in one touch because they feel
it's catchy.
It's a catchy title, but it's essentially, it was created by our officers in La Colle to help deal with the situation there. They are having the person fill out a form to capture all the questions around all the various inadmissibilities that would have an impact on their access to the board. And then we have an interview with them to question them. This has now been nationalized, and so we end up in a space where we're trying to determine, can they go down the one-touch path? In terms of process, so we have about 70% of all the applicants are processed using one touch. About 15% are found ineligible, so we complete the full process on those people.
So what happens before the one touch? Before the touch, what's happening?
The title of the process, I think, creates the illusion that there's something that's different that's really going on. The only real difference is that instead of having an officer that's being paid a significant amount of money sitting down and collecting all the details of their entire refugee claim, we are staying focused on the national security and admissibility issues at the port of entry. And then when it moves over, they'll fill out their application. It will go into the portal that IRCC administers, and then all the security screening and reviews that I've described previously would take place before the board will have it, and we will decide whether we wish to intervene or not.
So,
thank you, Mr. Bush. Thank you, Mr. Zuberi. Next, we go to Monsieur Deschênes pour 2 minutes.
Mr. Deschênes, 2.5 minutes. Thank you, Madam Chair. Madam Chair as well, currently what is the percentage of asylum claims that arrive in Quebec compared to the national average?
37.
Et ça, c'est en...
37, pardon.
Oui.
37. And that's from what date? December 31st. Madame Brossard, you gave me a lot of statistics today, and I thank you for it. But I'd like an answer in writing just to make sure I wrote everything down correctly. So what I would ask is the number of asylum claims accepted without a hearing since 2019 in Quebec. Well, first of all in Canada, and then distributed by province. The processing time for asylum claims by province from 2015 to date, and the percentage of asylum claims arriving in Quebec from 2015 to 2025. You understand, when it's the address that they're given, whether they're there or not. No, I understand. Yes, I understand the limits to what numbers can tell us, but... And now a question for Mr. Jason Holman. Can you hear me, sir? How is it that there is no distribution of asylum seekers throughout the provinces, and that Quebec represents 37% when we only represent about 20% of the Canadian population of Canada? Well, asylum seekers can arrive where they wish. That's a right enshrined by the Charter. So discussions are ongoing to see whether we can try to receive asylum seekers more equitably across the country. I think there are discussions ongoing between the minister and deputy ministers, and the result for the moment was an agreement with New Brunswick and Nova Scotia, which accepted a few hundred of asylum claimants each. Okay. So the question that asylum seekers are entitled to mobility, has that been tested before the courts? Answer. There has been judicial review. I don't know whether it was tested before the courts. How? Inaudible for the interpreter. Perhaps the recent ruling on the asylum seekers and their access to childcare in Quebec might shed some light on the matter. You'll understand the claim from Quebec, and it has been repeated because, of course, asylum seekers represent a significant number of residents in Quebec. And to your knowledge, are there still discussions ongoing to better spread out asylum claimants more fairly? Thank you, Mr. Duchesne.
It's because you're so charming. Your questions are so excellent. So peut-être on peut répondre à la prochaine.
Perhaps we could get to that at the next round.
Minutes for Mr. Where are we here? Oh, Mr. Menegakis.
Yes, thank you, Madam Chair. Madam Chair, I'd like to give verbal notice of the following motion. That further to the testimony from the Immigration and Refugee Board of Canada, IRB, on March 9th, 2026, related to the presence of agents of the Iranian regime and agents of the Islamic Revolutionary Guard Corps, the IRGC, in Canada, and further to the committee's study on Canada's immigration system, and further to the imminent danger that the presence of IRG officials and regime agents in Canada may pose to Canadian public safety, the committee report the following to the House. 1. Government officials have admitted the known presence of Islamic Revolutionary Guard Corps, IRGC officials, and regime agents residing in Canada. 2. There are gaps in legislation and procedures that may allow IRGC officials to avoid detection prior to arrival and deportation after. 3. The government should exercise the full force of the existing law regarding the designation of the IRGC as a terrorist entity, specifically by expediting the execution of deportation orders of regime officials who are non-citizens under the Immigration and Refugee Protection Act. 4. The government should immediately undertake a comprehensive review of the Immigration and Refugee Protection Act with an eye to modernize it to prevent regime officials from avoiding deportation by A, clearly ensuring non-citizens are deemed inadmissible if involved in regime-linked businesses, spreading propaganda or human rights abuses, B, extend inadmissibility to immediate non-citizen family members of regime officials, and C, create an exemption for non-refoulement protections for inadmissible non-citizen regime officials proven to be complicit in human rights abuses. 5, the Immigration and Refugee Board of Canada, IRB, should immediately release the name of the alleged non-citizen regime official referred to in the February 6, 2006 Global News report entitled Latest Alleged Iranian Regime Official Found in Canada Wants His Identity Hidden, and forthwith provide a written explanation of why the IRB banned reporters from publishing his name to the Standing Committee of Citizenship and Immigration. 6, the government should, within 30 calendar days following the tabling of this report, table a report to Parliament explaining why it has not made public the identities of known non-citizens who are Iranian regime officials or agents who are currently present in Canada. And 7, it is imperative that the government stop approving refugee claims from nations with regimes hostile to Canada without an in-person interview being conducted first.
Thank you, Mr. Menegakis. Can I just ask whether or not, are you moving this or are you just putting this on notice?
No, verbal notice.
Just
giving
verbal
notice today
Okay.
of the motion I
Okay.
just said. Now, I assume I have a little bit of time left?
Yes, you have 1 minute and 52 seconds.
Oh, wonderful. So my question is to CBSA, to you, Mr. Bush. CBSA's internal target in the last year for removals of high-priority foreign officials, including those who are inadmissible due to war crimes and security threats, was 80%. Why is it the CBSA's position that allowing 20%, potentially 20% of people who are security threats or have committed war crimes to stay in Canada as being acceptable?
So performance measures are performance measures to evaluate the efficiency of the program that's in question, in this case, removals. There are a lot of factors that go into being able to remove someone from Canada. Obviously, we want to remove as many of those people as we can. It's our top priority, removing people who are inadmissible for serious grounds. So the stats I was given was we removed over 1,000 people that were inadmissible in 2025 that fit into those categories.
Sorry, on your website.
Yes.
On your website, it says your target is 80%.
I know what.
So that means there's 20% that, you're okay with. Is that fair?
No, I don't think that's fair because a performance measurement is different from what our objective is. Our objective will be to remove as many of them as we can, but there is a reality that not everybody is removable all at the same time.
You only got one. One deportation since 2022, I believe. One. Your target is 80%. Let me ask this: how many CBSA
Mr.
executives?
Menegakis, that's time. And Mr. Bush, thank you very much. That was it. You still have another round, though. Okay, Ms. Sodi, 5 minutes to you.
Thank you, Madam Chair. My questions are to the officials from IRCC. So my office has recently been overloaded with emails regarding the interim federal health program, through which asylum claimants can access health coverage while their claims are being processed. Could you explain what this program covers and why it exists?
Sure. So the interim federal health program provides limited and temporary health care coverage for refugees and asylum seekers to help address any urgent and essential medical needs while they wait to become eligible for provincial or territorial health insurance should they become protected persons. They receive this interim federal health care for the duration of their refugee determination process. For those who are unsuccessful, of course, they will be removed and their coverage ends once the removal orders have been enforced and they have left Canada. The important part is that people are given access to benefits in a similar way as low-income residents, and the coverage is for basic health care. services such as hospital care, physician care, laboratory services. They also receive some limited supplemental coverage on par with that offered to social assistance recipients in provinces and territories. So it's designed to ensure that we are addressing the healthcare needs of this population for the time that they are in Canada.
And how do the adjustments under this plan help ensure that IFHP remains sustainable while protecting essential health care for asylum seekers?
Yeah, the recent changes were to look at adding a co-payment fee of $4 for each prescription and 30% of the cost of supplemental coverage. That's designed again to help address the financial sustainability of the program.
Perfect. And overall, what steps is IRCC taking to improve communication with the public about how Canada's asylum system works and what its safeguards are?
Yeah, I mean, we communicate fairly regularly both about the system and how it works. We do that with information on our website, but we also engage with frontline stakeholders, ensuring that they have information, especially when any changes are made to the system, so that we can ensure that their engagements with those refugee claimants provide accurate information. As we look to any changes, we will also be continuing to update our website, push information out both to claimants and giving them handouts and information, but also to those organizations that are working with them.
Okay. How much time do I have left, Madam Chair?
150 seconds.
Okay, perfect. So really quickly, are you able to inform the committee on how IRCC is working with CBSA, IRB, and other public safety partners to improve the security screening process while also managing and meeting targets in the immigration levels plan? And if anyone from the IRB or the CBSA would like to jump in to answer this question, you're able to do so.
I mean, I would defer to CBSA on the sort of security screening process, but you're right. I mean, all of these things are well coordinated between all of the three departments as we look at the asylum system, because I think, as was commented before, it is a very integrated system where information and cases flow between the organizations, and we're continuously looking for ways to streamline that. Some of the measures that we have under Bill C-12 that is still pending in the Senate will improve the asylum processes and improve some of those handoffs between organizations. But I don't know if my CBSA colleague wants to add anything on security screening in particular.
You asked about the question, if I recall, had to do with the levels plan and the impact on security screening. Mm-hmm. So I think it would be fair to say, as the level of effort on the number of new permanent residents and new temporary persons coming into the country, whether to study, work, visit, is reduced because of the changes in the levels plan, obviously the demand for services on that side of, because there's three pieces to security screening. There's temporary resident screening, there's permanent resident screening, and then there's asylum security screening. And so it affords us time to dig into cases not more effectively, but it will help us to reduce some of the inventories that we currently have.
Thank you, Mr.
Perfect.
Bush. Thank you, Ms. Sodi. Next, we go into our fifth round of questions. And so we begin with a combination of Mr. Redekop and Ms. Rempel-Garner. Ms. Rempel-Garner first.
Has there been any discussion in your department about advising the government to refer or ask for a Supreme Court reference on the immigration components of Bill C-12 in light of the Supreme Court ruling that came out on Friday, specifically if Bill C-12 will be compliant with the ruling as it pertains to the Section 15 violation that the court found?
All I can say on the Supreme Court ruling from Friday, because it is relatively recent, is that I understand the Attorney General is looking at the ruling and assessing it, as well as any impacts on federal legislation.
Does the government have any plans on referring or asking for a Supreme Court reference on any other components of immigration legislation in light of the ruling? I'm thinking about things like the point system, other stuff that people have said would now be ruled unconstitutional.
As I said, I think it's too early, given the decision was just taken on, or just tabled on Friday, for us to have a good picture of the way forward.
In your opinion, should, let's say, the bill, the immigration components of Bill C-12 be found through a reference unconstitutional, would you see the only way to uphold that those particular provisions in the bill would be through the use of Section 33 of the Charter?
I wouldn't want to speculate on any of the way forward. My understanding from the information I've seen is that the Supreme Court ruling was specific to the daycare system in Quebec.
Thank you. To Mr. Redekop.
Thank you. Madame Brassard, you spoke with my colleague, Mr. Duchesne, about tabling some information, and I have a similar request, and so I would just add, I would give you my request, and you can put the two together and make it one request. So what I'd like is a breakdown of the total number of claims and separately the total number of persons accepted using the policy of file review. And I think Mr. Duchesne suggested from 2015, so that's fine. And I'd like it broken down by country and claim type. And if I think it's reasonable to expect that in about within, let's say, 2 weeks. Does that seem like a reasonable time frame?
You said number of claims, and the second one I didn't get.
Broken down by country and claim type.
Yeah, but before that, number of claims and number of people?
Number of persons accepted using the policy of file review, yeah. Yeah.
Yep. Okay.
Okay, and also I've got some additional questions for you. Regarding this policy, the file review policy, before it was implemented, did the Minister of Immigration approve the policy of file review?
There's no need for that.
Okay. Did Cabinet approve the policy?
There's also no need for that. We are operating within the legislation.
So you did this entirely on your own authority?
Since 1993, the process has been put in place internally, yes.
Okay, so this is something that the IRB has done within their own authority?
Yes.
Okay. And if the Minister of Immigration asked you today to end the file review process, would you do so?
The board is independent. We operate within our legislation. That practice has been mentioned and supported both by the Yates reports, by an OHG report, and the few times that has been put to as a question to the federal court, the process has been supported. I see no reason for changing it.
Okay, so you are independent. You do not answer to the minister.
We answered to Parliament through the minister.
And just one question for the CBSA for Mr. Bush. You talked about in a different round. We were talking about the war in Iran right now, and you talked about mechanisms that are in place. Are there new mechanisms that have been put in place since the war has started? You can push the button.
Speaking?
Okay.
Yes.
There we go. So mechanisms, I don't know if I would say they're mechanisms. So we have the designated regime, which we've talked about at some length. We've got the designation in the criminal code on that. We have also, to support global affairs, Canada and the movement of Canadian citizens out of the region. We've also
maybe just to be more clear, in terms of security reviews and how you look at files, has there been any new mechanisms, has anything new been put in place since the war began?
So all I'll say is not that I'm aware of, but I can take that back and check.
Okay. Is that?
That is it. That's perfect timing. Next, we have Mr. Fragiscatos for 5 minutes.
Thank you, Chair. Mr. Bush, you were asked already about One Touch, but I want to go down that path again because we did hear at length at this committee, but didn't really have an opportunity for CBSA to put its view on the record. And I'll be very strong feeling that One Touch was basically a get into Canada free kind of thing. But based on what you shared with Mr. Zuberi, that's not the case. Based on what CBSA has put forward in other forums, that's certainly not the case. But can you share for us here at the committee what One Touch is, how it works, and whether it's based on sound security principles to ensure the public safety of Canadians?
I'm just going to quickly take you through a little bit of evolution of the last 10 years of refugee claims. So if we were to rewind to late 2016, early 2017, most of the increase in refugee claims was being driven coming from the United States. It mostly was impacting at a place that everybody is very familiar with, at Roxham Road. And so it was mostly the processes were impacting on our colleagues at CBSA, at L'École, and the RCMP. And so those processes generally to do a full refugee intake takes roughly 8 hours to do, okay? Well, 6 to 8 hours, depending on what the person presents in terms of issues. You then move into the pandemic. Of course, with border restrictions, numbers of claims drop right down because there's nowhere near as many people crossing the border. We then come out post-pandemic, and the number of claims coming into the, seeking protection in Canada, both at the land border and airport ports of entry and inland, all start going back up, and you're all very familiar with those numbers. So our colleagues in Quebec region, we first took an approach of deferring examination for folks. It's a provision in the Act that allows our officers to essentially reschedule the hearing. It was largely driven because the border restrictions that were in place did not align, when they were lifted, did not align with provincial restrictions being lifted, and so we still were only able to have so many people in a space at any given time. So for their health and safety, for the officers' health and safety, we had to take certain steps. That led to its own problems that we had to quickly address with IRCC. And then we moved into One Touch. One Touch, as I have tried to describe, we are assessing admissibility right at the port of entry. They can, based on all of the information that we have available to us at the port of entry, so that's including systems like CPIC, it's including systems like GCM, the Global Case Management System at IRCC, it's including the biometric checks that we do both with the RCMP as well as our partners, international partners, to validate identity, but also to validate is there any known information on these folks, and then we make a determination at the port of entry. Please keep in mind, that's the same information that we would have had available to us in the previous process. The only change is that we are not spending the time with the client to collect their claim, fill out all the paperwork, and start enrolling their basis of claim. We are checking the identity based on the documents they have, based on their biometrics. We are validating the identity. That then triggers off the application process in the system, and then over into security screening and all of the processes I've already explained. Is there a comfort level amongst everybody? I know that colleagues from the Customs and Immigration Union have expressed concerns about this, but I think we need to be 100% clear. This was created by our officers and was brought forward as a recommendation by our officers as a way to be able to not only manage the volumes, but also to deal with our agency's primary responsibility for the safety and security of people at the port of entry.
I'm just going to pick up in the remaining time on that point that you made there. This is not, if I understood you there, this is not a management decision coming on from up high. This is a recommendation that that officers gave.
The officers developed this at L'École. They put that forward. The decision to nationalize it came in discussion with all of the regions across the country to implement it nationally.
Thank you very much.
Thank you, Mr. Bush. Thank you, Mr. Fredescaros. Monsieur Deschênes, c'est à vous, 2 minutes et demie.
Monsieur Deschênes, you have the floor. Thank you, Madam Chair. To continue my discussion with Mr. Hallman, I'd like you to submit in writing the reports, documents, and research on the possibility of better distributing asylum seekers among the different provinces. And if you could respond orally, immediately, I would accept that as well. Well, everything that I could say is that I know that there were discussions, at high-level discussions, to weigh the interest of the provinces to participate, to accept other asylum seekers. But I know that the result has been Nova Scotia and New Brunswick signing agreements. If you have written documents to support that, I would be very interested. Mr. Bush. How did the beginning of the war in Iran affect CBSA so far?
I will tell you what I know, and I will tell you what I do not know.
Okay.
Préférez-vous que j'explique en français?
Would you rather that I answer in French? Okay. At the beginning of this conflict, our organization decided to change the positions for our officers outside of Canada working in missions overseas, embassies, to help global affairs with to leave the Middle Eastern region. Furthermore, well, not furthermore. That's all I know for now. How many asylum refugee claims have been received? I don't know. For the numbers, on the number of refugees, I really don't know. We can obtain that information since last week to determine whether there has been an increase in asylum claims from Iran. Thank you. I would be interested in that. Mr. Deschênes, thank you.
We have 6 minutes remaining. I'm going to give 2.5 minutes each to the Conservatives as well as to the Liberals. We start off with Mr. Davies.
Madam Chair, I'm going to be splitting my time with MP Ho. But I will just very quickly, I think today we verified that detention capacity has been significantly reduced in Canada at a very problematic time. And we've also determined that people have been released while being on a deportation order prior to being deported. Mr. Bush, you made reference to provincial detention. Does the CBSA rely on the province for detention capacity, and does the province have independent authority to release a detainee without the CBSA's knowledge?
So for your first part, again, I'll take a little, I'll make this quick. We used to use, in combination with immigration holding centers, some capacity at provincial detention facilities across the country. Provinces have systematically withdrawn from that particular activity through notifications over the last several years. In terms of your second question, when we were using those, no, the only organization that could release them past the 48-hour, the first detention review is sitting to my left. It's the Immigration and Refugee Board. It's the only organization that could order their release. The provinces would have no authority for that.
1 minute.
Okay, I'll pass this over to Mr. Ho.
Thank you. I have a question for the officials here. Would it be possible, could you table for this committee every version of the instructions governing the streaming of less complex claims at the RPD since 2017, and the countries listed on those instructions and any communications with the IRCC, DMO, or Cabinet regarding the creation or modification of the list within 30 days? Thank you. How much time do I have left? 30 seconds. Questions for anyone on the panels. How many members are associated with terrorist listing organizations that have active claims at the IRB? Is that something that you'll be able to provide as well? Out of the, maybe you can provide it later. You probably don't know the answer now. Can you provide it at a later date, within 30 days?
Thank you, Mr. Ho.
Sorry, was that a yes that she would provide?
I think I saw a nod, Ms. Brassard. Madame Brassard, is that okay? Okay. Thank you, Madame Brassard. Thank you, Mr. Holt. And lastly, to finish us off is Ms. Soti.
Thank you, Madam Chair. My question is to you, Mr. Bush. As you know, Canada's new government recently introduced Bill C-12, the Strengthening Canada's Immigration System and Borders Act, to help stabilize the system and give law enforcement the tools needed to keep Canadians safe. Can you outline what measures are included in this legislation that will specifically support CBSA in its work to maintain security and integrity in the immigration system?
Thank you very much. So I've tried to reference it a couple of times, but the first and foremost is the concern that all of the measures for security screening and intervention work will be completed before the board will be referred the claim for determination of the actual claim. So that's the first piece. The second piece is that earlier in the process, so right now, there will be one application, so we will also be getting the basis of claim submitted by the client earlier in the process. So right now it's a two-step process. There's the application for the refugee claim, and then the submission of the basis of claim form, which is the foundation for the board's work. However, all of that information will now be provided through the application, which is also covered in C-12.
1 minute.
So that we can do security screening on the full and determination of whether we want to intervene on the full package of information that is being considered after we're finished our work at the board.
Okay. Can you tell us what immediate or near-term effects you predict this legislation will have once it comes into force in terms of stabilizing the immigration system? Or maybe, actually, sorry, if an official from IRCC can quickly answer that.
Yeah, I mean, one of the core measures that, and as my colleague from CBSA was listing a couple of them, one of the core components of the bill are a number of process changes for the asylum system. All of those are really designed to address some of the areas of bottleneck that we found within the system and improve the information flow between the three organizations. So they should lead to efficiency gains in how we process those claims and allow us to do more faster. They will also generate some improvements for
Thank you,
clients.
Mr. Holman. Thank you, Ms. Soti. And I want that ends our session today. So I want to say a very, very warm thank you to all of our witnesses. It was a very
Okay. So we're going to call it there until question period. Carney is in Ottawa, but it doesn't show on his itinerary that he's coming to question period, so I'm going to assume he's not going to be there. Pierre did a presser earlier in Ottawa in Parliament Hill, so I'm assuming he's going to be there. So it'll be Pierre versus some Liberal ministers. And then afterwards, we've got the Ethics Committee. We've got the Commissioner of Lobbying. And Conservative MP Barrett's been really good in that committee, trying to expose how Brookfield is lobbying the government, and Carney just went to Australia, Japan, India, and a lot of his announcements were tied to some investments that were lobbied by Brookfield. So that'll be pretty interesting to watch. And I put the link in chat. There's the link for question period, and I will see you guys in an hour. Cheers, guys. See you soon. Oh, and Megan, thank you so much for the 5 gifted. I really appreciate you gifting memberships. Okay, there. We'll call it there. See you guys soon. Bye-bye.